in the appeal of Dorsey McPhee against Colina Insurance Limited.
Good morning.
Morning.
We've started slightly later than had been intended, so you can treat yourself as having another 8 minutes beyond the formally allocated time.
My Lord, thank you very much. My Lord, in this matter I appear on behalf of the appellants together with my learned friend, Mr. Pennington Benton, and for the respondents we have Mr. Kershid, KC, I should say, and together with Mr. Bailey. My Lords, before I start with some introductory observations, let me say this, that I am fully aware of the points that are being made in the respondent's written case against me, and your Lordships can rest assured that I'm going to deal with each and every one of them in the course of my submissions. Now, by way of introductory remarks, I want to say this. In this case, the appellants took out a policy of life assurance with an investment element. It was part of his retirement plan. The policy contained no table setting out what rates the cost of insurance would increase by, and that's the point that I'm going to develop very shortly.
Is there a finding to that effect?
My Lord, there is no finding to that effect.
No.
There is no finding to that effect, but in fact, it is patently obvious when I take your Lordship through the evidence that the respondent's case was not that they applied the rates in the table, but they applied rates that they had at their office. I say that for them to have succeeded on the guaranteed cost of insurance, it's not enough for them to have adduced evidence of custom to say what a yearly renewable term means. When one looks at the contract, the increases would have been in accordance with a table. They needed to show that, in fact, the rates that they applied were equivalent to the rates in the table. In fact, were the rates in the table.
Well, there are two different points there, aren't there? One is whether there was a table, and the other is whether, even if there was, whether the rates applied were those in the table or not.
They are two separate points.
And there's a further point as to where the burden of proof lies, and the board would welcome assistance on that matter.
Yes. Well, the reality is that two policies were disclosed, one annexed to the statement of claim, another one was included within the bundle by the insurance company. None of them included the table of guaranteed costs of insurance charges.
So the insurance company made discovery of a...
Yes, and included it within the bundle. And it did not include... And there's also, I'll take your Lordships to this in due course, a letter from Mr. Colina's counsel to the insurance company, please provide us with a copy of the table, and the table was never produced. You see, one of the, and I'm really running ahead of myself now, but one of the overarching point that I'm going to make is that, in fact, the judge never really got to grips with how it is that it is being said that Mr. McPhee agreed to the rates that were applied by the insurance company. And there are a number of arguments that I'll deploy in due course by way of factual matrix, which your Lordships will see is important to this issue. And there are two ways in which the insurance company increased the cost of insurance. One was on an annual basis, and the other one was a 75% one-off increase in 2006 on the basis that the insurance company said that the policy had lapsed, and then they reinstated the policy in accordance with a specific procedure set out in the policy.
And that was the only time that there was a
And that is the only time that there was an increase post reinstatement. And I use reinstatement in very neutral terms. I'm not accepting that there was a reinstatement in 2006. Now, the Court of Appeal actually get it hopelessly wrong in my respectful submission. Because what the Court of Appeal do is they conflate the cost of insurance, the annual increases, with the 75% upon reinstatement. And that is patently obvious from the question that the Court of Appeal posed initially, and also the conclusion the Court of Appeal reached in paragraph 17. I'm not going to take your lordships to that at the moment. Again, I'm running ahead of myself because of my lord's questions. There is a dispute about what the judge actually found, and as I will explain, what the judge was on the evidence able to rationally find. Now, your lordships will have seen from the written statement of case produced by the insurance company that they contend that there could be important implications for the insurance sector in the Bahamas if the board decides that the increases in the cost of insurance in this case were not justified. My lords, the issues raised in this case are not as grand as that in my respectful submission. In any event, I can assure your lordships that I am not going to invite your lordships to interpret this contract in any way that affects, other than that it affects the parties to this dispute. And your lordships will see why when I develop my submission. The reality is that at best, from the insurance company's point of view, this was a badly drafted contract, something that was accepted by Mr. North, counsel for the insurance company, both before the judge and also in front of the Court of Appeal, where they've had to rely on extrinsic evidence to show that the guaranteed cost of insurance was envisaged to increase.
Well, they don't have to rely on that, actually. It's fairly clear when you read the policy, isn't it, that it is intended to go up in accordance with the table.
In my submission, no, when one looks at the policy. But in any event, that extrinsic evidence, which is the policy illustration, it doesn't actually assist with the meaning of guaranteed cost of insurance.
You don't have to go to the policy illustration. You just go to the policy itself. It's an initial amount, and you have a clause that if but only you had the table, would lead to an increase.
Yes, well, that is my lord, if the only way that I say that the insurance company could have got home on this case was by showing to the satisfaction of the judge that they had applied the rates in that table.
Yes. Well, I mean, that's
a different point.
Yes, no. Yes.
Yeah.
But assuming that your lordship is right, I'm going to be arguing that your lordship is wrong in due course when I take your lordship to the policy. Yeah. But assuming that I face a closed door, and that in fact the position is that you look at this policy and it's envisaged that it's going to increase, that the 74 odd is just the initial amount.
I mean, one background fact which one might be taken to know is that unfortunately, between the ages of 54 and 65, one's risk of death does increase.
Well, it does. Indeed, it does.
And so it would be surprising if the annual risk remained the same, and the charge that reflects that.
My lord, I will come to the policy I will come to a policy in a few moments, but your lordship has the point that I wish to make, which is, well, it's the table. How is it alleged here that Mr. McPhee actually agreed to these rates? And of course, this is important.
That all depends upon the burden of proof, because the respondent asserts that the burden is on the plaintiff to establish a breach of contract, and you assert that it's on the insurance company to justify deducting money.
Exactly.
But there's no authority quoted by either side in relation to that interesting point. And
no, but let me perhaps focus it from this point of view. That in this particular case, we say that the insurance company, its own case, it's pretty obvious on its own evidence that they never applied the table of guaranteed cost of insurance.
Well, they admitted, because they claim that they applied an uplift, and so at least from that point, they didn't apply the table.
Yes, they didn't apply the table, and but they didn't apply the table, certainly not for the 75%, but The point that I'm making is in relation to the annual increases. They didn't apply the table because they applied a schedule of rates which they had in their office.
And where's that in the documents?
And that, no, it's not been disclosed, the schedule of rates, but I'm going to take your Lordship to the evidence, and your Lordships will see that it was never contended by the insurance company that they applied the table of rates annexed to the contract.
Yes.
Okay.
And that is the soft underbelly.
I think I saw that evidence, and I didn't think it excluded the possibility that the schedule of rates in the office was based upon the table.
Well, my lord, nobody asked. You see, in this case, nobody's cross-examined Mr. McPhee and said, Mr. McPhee, you received this table, didn't you? And you knew that it was going to be increasing, the rates were going to be...
Was it put in issue whether, in the pleadings, whether Mr. McPhee had received the table or not? I thought that the respondent's case was that this is a point you're raising now. Nobody ever challenged the non-receipt of the table.
Well, my lady, I say it's simply not good enough for the insurance company to get home on a case by applying, on its own evidence, by applying a schedule of rates that's not the table.
But we don't know whether or not the schedule of rates was the table, do we?
Well, let me answer that question. Ms. Shatlani could have, and in fact was given, ample opportunity to say that in her evidence. She never said that in her evidence. She never said the table or the rates are the table and the table are the rates. Never. That's not the...
She asked that.
Well, my lady, she was asked, how do you justify these increases? And it would have been very easy for Ms. Shatlani to have said, well, Mr. McPhee, you agreed that table, these rates are the table. And she never said that.
No, it's Mr. McPhee's job to put the case he wants to run to the witness.
And I'm going to take you, my lady, to those exchanges, and I'll be making comment in due course in relation to that.
Yes, well, we better let you develop your submissions, but we are, as a court of second appeal, not likely to go behind the findings of fact of the courts below.
My Lord, I hear, my Lord, and I can assure my Lord that I'm going to be dealing with all these points. But my Lord, your Lordships will have appreciated from the facts that the insurance company actually takes over this particular policy from Canada Life. And this policy does not say that the rates applicable from time to time to a particular risk class, that we apply to a particular risk class, would be essentially, or that the cost could increase in that way. It doesn't.
Well, that's the point, as I understand it, having a guaranteed cost of insurance. You lock in the rates as they are at the time.
Yes, and it's important, that of course, the judge makes an important finding in the first sentence of paragraph 9 of her judgment, where she says, a key feature of the policy is low-cost term insurance with an investment feature and the creation of an investment account. That's what she says. Now, the cost of insurance, of course, has an impact on the investment value. For the investment value in the investment account to be maintained until the end of the term, the consumer needs to know, needs A, to know, and B, to agree to the cost of insurance and how that increases. And there has to be a high level of transparency in the contract with regards to the purported increase in the guaranteed cost of insurance. At the very least, there has to be a mechanism in the contract to calculate the increases in the cost of insurance. If the consumer doesn't know that mechanism, he doesn't know by how much he needs to increase his premiums in order to maintain the investment value in the account. That has to be uncontroversial in my respectful submission. There was no mechanism other than the table. And of course, I also refer your lordships to the term to the words guaranteed cost of insurance charges, guaranteed cost. These are easy to understand words and in the English language. And of course it cannot mean, in my respectful submission, a freewheeling discretion on the part of the insurance company to increase the cost of insurance in accordance with rates that they may have and may apply from time to time.
Yes, which points to, surely it points to there having been, under this style of policy, a table which set out what the guaranteed rates were year on year as you grew older.
Yes, and another party's produced it, and I say that it's the insurance company that says that they applied increases in accordance with the contract. At least they have an evidential burden to discharge in relation to that.
Do you have any authority to support that, or is it just a matter of working from principle?
My Lord, I don't.
No.
I'm afraid. But that is
But this is a very different challenge from that which Mr. McPhee first made, because he initially was saying there was no entitlement at all to increase annually. You are accepting that there probably was an entitlement, but the insurance company hasn't proved that it operated within the contractual boundaries.
My Lord.
Is that right?
I am not going to concede that Mr. McPhee was wrong, because I have no authority to concede the point, but I am not going to be pushing that argument that I know is going to be firmly shut in my face.
I think you're putting it. I think you're putting it two ways onto your sort of stronger point is to say, well, they should have to prove that there was a table, and they haven't proved that, and in the absence of a table, there's no right to increase. Alternatively, even if they establish that there was a table in existence, that's not good enough, because they have to show that the increases were contractually authorised, and they haven't shown that because they haven't shown what was in the table.
My Lord puts the point better than I have put it in my opening. Now, there is perhaps a floating, a bubbling in your Lordship's mind, the point about the annual statements and what impact the annual statements. Let me just outline what my arguments are going to be. Well, I'm not going to repeat this argument. There are two arguments that I use in relation to the annual statements. The first is a fundamental point, the other one is an evidential one, but the fundamental point that I make is that it's a cornerstone of trial advocacy that if you're going to use evidence in order to contradict what somebody says in a witness statement or in direct oral testimony, you've got to put that evidence to that witness in cross-examination. Mr. North, counsel for the insurance company, never took Mr. McPhee to the annual statements, never said, Mr. McPhee, these are the annual statements. You received these, didn't you? These show X, Y, and Z. And in the absence of that, in my respectful submission, it's just not appropriate for the judge to have made the finding that she made in regards to that, because all you had was the unchallenged evidence of Mr. McPhee. The second evidential point that I make is that the annual statements, they may show a balance, but they don't actually show the rates by which the increases took place. And taking a step back, if what we're now saying is, well, the insurance company not only has relied on extrinsic evidence to show what something means, but now they've got to show, they've got to use annual statements to show that through a course of conduct there was agreement to pay these increased rates. That's a very weak position in my submission for an insurance company to be in. On the 75% increase, I say this is the outline of my submissions. That's the one-off in 2006. There is a qualitative difference, my lords, between the evidence that one needs in order to prove a lapse. In other words, there were no longer funds sufficient to cover the cost of insurance or charges, and the evidence that you need in order to prove a reinstatement. Because a party can come to court and can say, This is my evidence of system. This is my printout in accordance to that system. This shows money's in, money's out, the charges, by money's out I mean the charges, and the balances on particular dates. But you see, the contract here was very specific about how it envisaged that reinstatement was to take place. And that's the only way, it's by following that procedure, it's the only way the insurance company justifies a 75% increase.
But 75%,
and those steps...
When was there a 75%?
In 2006, my lady.
Do you accept, I mean, it's not apparent actually, that there was a 75% increase. Looking at the rates, they didn't go up 75% then.
Well, I have, mathematics has never been my forte, I have to say. And on the basis that discretion is the better part of valour, I decided not to raise the point before your lordships. But when I was looking at the tables and I'm doing the maths in my mind, I couldn't see how the 75% actually arose.
We've had the same problem.
But the wording is not exactly saying there's a 75% increase in the general cost of insurance. It's some other phrase that's used, which I assumed didn't actually mean what one might have thought it meant something else. It's a 75% increase in the rate or something.
Yes, because
I don't know what the rate is.
The way that I've understood it is that essentially you've got these annual increases, and on top of that in 2006, the insurance company then also imposes a 75% increase in the rate. So from 2006 onwards, you're starting from a higher base in those rates. So they're increasing annually, but you're starting from a higher base. That's how I understood the insurance companies.
So it's a 75% increase in the rate of increase rather than...
In the cost of insurance.
No, it isn't the cost of insurance. That's the problem. Are you saying that there's a 75% increase in the rate of increase rather than in...
No, in what the cost was in 2006.
That's because the cost is based on a rate applied per $1,000. And so if the rate is 0.5% or something per $1,000, then that's how the cost of... that's how the cost monthly deduction is calculated, and if you increase that by 75%, it goes up from 0.5 to just under 1%, let's say.
Yes,
that's the concept, isn't it?
That is the concept. But let me just drill down on how the insurance company can get to 75%. No, not really how it chooses 75%, because nobody knows. And the judge in her judgment says, look, it could have been less, it could have been more. But how do we get to a position where the insurance company says we're entitled to impose 75? And it's upon reinstatement in this sense.
I am still totally confused as to what the 75% applies to, because at page 18, paragraph 9, it applies to effectively increase both the premiums and the guaranteed cost of insurance. The premiums stayed the same. And the witness statement at page 563, paragraph 19, has the same submission, I think. And there's also another reference to it at page 616, paragraph 12. So I just don't know what how the 75% was supposed to impact.
Well, it certainly impacts on the cost of insurance that is then added to what my client had to pay. That's in simple terms. How they get there, that is something that Mr. McPhee grappled with in cross-examination. I mean, he cross-examined, as I'm going to show, on all these points, and well, tell me how. And it's never really been explained very satisfactorily. But
we had the insurance company's response to Mr. McPhee's claim at MS 533, where they summarised the transactions between year 1 and year 11. And we see there in year 4, which will be the 2006 year, or 2006-2007, we see a hike in the guaranteed cost of insurance of about 30%. While in the other years, the increases range between 7.5 and 10%. So that something clearly happened that year. But
It doesn't obviously correspond to 75%.
it certainly doesn't correspond to 75%.
No. And of course, part of the problem in this case was there was no expert evidence of any kind.
You don't really need expert evidence, you need someone from the insurer. Maybe we're addressing with questions to you that we should really address to the insurer.
Yes,
who
that may
should,
well be.
know how this was, what they meant by what they pleaded, because it doesn't seem to be what one would naturally assume they meant. It may well be what my Lord Legate suggested.
But let me just address how contractually they say that 75% arises. What essentially they're saying is, well, we're entitled to impose this 75% levy upon reinstatement. Now, for that to be a submission that succeeds, as indeed it succeeded before the judge, although there's a question mark about what the judge actually finds. What you need is evidence of an application to reinstate. Evidence that Mr. McPhee essentially provided with that application evidence of insurability, which includes a medical. Because this policy, they say, had lapsed for more than 90 days, I'm going to take your lordship to a document that says that the document they should have used, it's in the bundle. So it's an application in accordance with a document, filling the document that's already in the bundle. They then get the application and the insurance company looks at it and assesses risk. Then the insurance company makes a decision, because lapse means termination of the policy. So they would have to make a determination. Do we want to continue insuring Mr. McPhee? And
it's not meant to work like that, I don't think. I think you're maybe giving too much away. It's meant to be an option to renew if you fulfil the requirements.
Yes.
And the only discretion in the requirements is whether your evidence is satisfactory of insurability. Apart from that, if you fulfil the requirements, you've got a right to reinstate.
Yes, but my lord...
And obviously, if you don't know there's a requirement to pay an extra premium, you can't... Well, then there isn't one.
Yeah, but the insurance company, what the insurance company is saying is, you've got to submit this medical evidence under the first clause in the reinstatement clause in the policy, and then under the 5th one, we are entitled, because it's a requirement of the insurance company, they say, to impose this extra 75%.
I know, that's what they say.
Yeah, the only way that works, and can only work, my lord, and I'm sorry that I spoke over your lordship, I apologise, but the only way that works is if, of course, they make an offer to Mr. McPhee. They say, right, well, we're prepared to reinstate on terms, Mr. McPhee, that you agree to pay 75%, and Mr. McPhee's got to agree. And the problem here is that there's no agreement.
If you look at page 79, which is where the table is, you see the account is all overdrawn, very seriously overdrawn. And then suddenly on the 21st of June, Mr. McPhee pays in over £1,500 to clear the...
My lady, I don't have 79. That's not...
79, MS 79.
No, that's a page number from the trial, I think. It's 21.
21, I think. Sorry. Thank you.
So this is what we're talking about. The account balance is getting steadily more overdrawn as all these expenses and guarantees and waivers all come out and there's no money going in. And then suddenly on the 21st of June, Mr. McPhee pays in two very substantial amounts, one of over £1,000 and one over £500, and that clears the debt and puts the account back in credit and leaves a bit of money in there, and then on the 1st of August, he pays in another substantial amount. And then that's gradually eaten away. Now that's the period that we're talking about, isn't it? This is the reinstatement after a long time of no premiums being paid and the account being overdrawn. So if he pays in that money and the insurer accepts that by continuing to deduct the amounts, isn't that what we're talking about, the reinstatement? Why if nobody wants to go through this procedure that's in they don't want to impose any more medical checks, he doesn't want to do it, why isn't that the reinstatement of the account?
No, I agree entirely with your lordship. In fact, simply because, and you see, simply because the insurance company continues to accept payments, doesn't mean that the policy is being reinstated in accordance with a procedure in the policy as they interpret the.
I mean, the logic of your argument is that the policy never was reinstated.
No, the insurance company accepts payments. If there is a lapse and the insurance company accepts payments, are we seriously suggesting that, and has done over a period of 8-9 years, that policy is not reinstated?
No, so you say they waived the requirements. I mean, your client did not pay. One of the requirements was to reinstate. The insured had to pay in 3 months in advance, I think. And he didn't do that actually.
I really wonder if this argument is open to you at this stage of the proceedings. If you look at page 6, at the plaintiff's statement of claim, paragraph 10, he says, the plaintiff asserts that if a premium ever went unpaid and the policy lapsed, he had it reinstated within a week or so upon such notification. So his case was that the policy lapsed and it was reinstated. It wasn't an issue before the judge at first instance as to whether there had been reinstatement. He accepted it.
No, my lord, because paragraph 10 has got to be read in the light of paragraphs 13, 14, 20, 21 and 22. And paragraph 13, the plaintiff asserts that it was in March 2014 when attempting to pay premium due on the 9th of February that he first discovered the policy had lapsed. That's what he says.
But how can he not know that his account was almost £1,000 overdrawn, and that must have been why he suddenly paid in £1,500 on one day?
One, because he never, according to him, receives the annual statements, a position that he is not challenged on in cross-examination.
But a moment ago you accepted, I thought, that the policy did lapse and was reinstated.
No, my lord.
Because otherwise the result would be just lapsed and
no, my lord. I don't accept that the charges I don't accept that the increases, in other words, the annual increases or the 75% are valid increases, and therefore
totally understand that
you take that out of the equation. There's no lapse. And Mr. McPhee
there is a lapse, and it was because it lapses automatically when you haven't when you're in debt for 60 days. And you accept that it was reinstated. The issue surely is solely whether a charge was validly levied of plus 75%.
No, it's never been accepted by Mr. McPhee. In fact, let me take your lordships to the relevant. I made a note because.
Sorry, what does he not accept?
That the policy ever lapsed. He never accepted that.
Well, it obviously did. You only have to look at the figures.
Well, but it's not the central part of your case.
Yeah.
I mean, your case is, even if the policy did or didn't lapse, nobody had agreed to the 75%, either during the course of reinstatement, and the 75% wasn't a part of the formula that was to be applied under the terms of the contract. Both of those points are, of course, are interesting points, if I may put it that way.
No, absolutely, my lord, and those that is our case. But if one looks at so the what I don't accept is that he has, in his pleadings, accepted that there was a lapse in reinstatement prior to 2014.
Well,
That's
I mean,
not the position.
I find his pleadings very difficult to read in the way you read them, because he's narrating historically how events have progressed, and by paragraph 11 he comes closer to the present time, saying he's 65, and then he gets on to the events of 2014.
Well, he says...
It seems to me that that he was not putting in issue any question about what happened in 2006 as to whether or not there was a lapse in reinstatement.
Well, I'll come back to the pleading in a moment,
But he didn't put in rival figures, and the figures show that the policy was in debt for months.
No, he did put in rival figures. It's the rival figures that, and then he never called the lady to give evidence. That's the...
Well, there's certain rival figures, but he didn't claim that he paid in more premium, did he, than shown here?
No, he says, I paid consistently the premiums that I needed to pay.
No, he claims that. He claimed that, did he? He claimed that he paid premium throughout all the period that he didn't.
He said, I was late. Yes, I was late, but he says the total. There was no dispute about the total number, the total amount of premiums that he paid. Never a dispute in relation to that. What he says is, if you take those premiums into account, and you take into account that they were not entitled to increase the cost of insurance annually, or the 75%, this insurance policy would never have lapsed. And if one looks at page 32...
So he says that there would have been enough money if they just deducted the $74
yes.
throughout.
Yes, that's been his case throughout.
Right.
And at page 32, this is a skeleton argument at trial, paragraph 3. So, at paragraph 3, the plaintiff is asserting the policy never lapsed. This is the skeleton at trial, so this is before the judge. So, at page 32, a skeleton argument for the trial. The plaintiff is asserting the policy never lapsed. That's the first few words of that paragraph. And then at 3.6, at page 33, your Lordship will see it submitted the policy did not validly lapse or had to be reinstated in 2006.
So do I understand that the plaintiff thought throughout that the policy continued?
Yes.
And was he monitoring it throughout the term of the policy?
Well, I can't give evidence from the bench. All I can say is that he wasn't cross-examined on... These are questions that you would expect counsel for the other side to be asking of Mr.
You'd expect them to be cross-examined if it was put in issue.
But
on the pleadings, it would be a foolish cross-examiner who asks questions
and also
which threaten to put in issue something which isn't in issue on the pleadings.
Well, it is an issue, my lady, on the pleadings. Let me return to the pleadings. So, at 13, he first discovered the policy had lapsed. That's in 2014.
Which page are you on?
Now I'm at page 6.
You would like to insert the word had purportedly lapsed there.
It says it first discovered that the policy had lapsed. Well, he does use the word purportedly in different parts of in his evidence. He uses the word purportedly in his witness statement. But the plaintiff had not changed the policy in any way at 14. There was no withdrawals and believed there should be at least $5,000 to $7,000. There can't be $5,000 or $7,000 if the policy lapsed. And believed there should be, and the plaintiff reinstated the policy and inquired as to why there was not sufficient value to pay the premium. The plaintiff was told by a Colina customer that was because of mortality tax. And then at 20, the plaintiff asserts that the compilation of the table, instead of providing a ledger of activity demonstrated, was never a ledger set up to record the debits and credits, and the plaintiff hereby demand production of the same in discovery, showing the dates of debits and credits and rates of interest applied to the account. And at 21, the plaintiff asserts that notwithstanding the terms of the contract and the policy illustration, the defendant administered the policy in a willfully dishonest and fraudulent manner. The plaintiff asserts that obviously no investment account was set up, the defendant simply received premiums, then unlawfully lapsed the policy on late payment. And at 22, the plaintiff asserts the figures produced in the table were simply manufactured and bear no relationship to the actual account. And at various stages, in actual fact, in the Court of Appeal.
The table with a capital T there, is that what was in the...
No, the table is a reference to a table at, let me just get the reference because I have it here. I think it's the reference is 533 of the bundle. And it's a letter.
That's the one I referred to a few minutes ago, where we see the guaranteed cost of insurance in between years 3 and 4 going up by 30%.
That's the one. That's the table that he's referring to, because up to that point, the table, I don't think it's actually suggested up to that point that the insurance company had imposed even a 75% increase on reinstatement. But that's the table that he is referring to. Now, also in the...
Do you know whether that is effectively a summary of this much longer table that was included in the defence?
My lady, I'm the wrong person to ask. Of course, this is a question for the insurance company at the end of the day. I surmise that that is what they will say, that this is a truncated version of that longer table in the pleading. But if I may, just on the pleadings, just finally end with page 8, a declaration at the very end, plaintiff claims, a declaration that the policy was unlawfully lapsed and remains in force.
Yes, that's a description of what happened in 2014. It's not talking about the historical facts of 2006.
But of course, my lord, the way that we get to a situation in which the policy lapses allegedly in 2014 is because of all the deductions and reinstatement. I beg your pardon? Yeah. And I'm being told by my learned junior, aggravated damages for the unlawful lapsing of the policy any time after policy year 3, and more recently in February 2014.
What we don't know, because
that's what it says.
The arithmetic done is whether the account would have been in credit, but for that hike in premium in 2007. In other words, if the insurer had simply applied the annual increase of, as my lord says, about 10% or just under 10% across the whole period, without that increase in 2007 of 25-30%, what effect that would have had on the balance of the account if everything else had remained the same. Presumably the increase in 2007 then affects the subsequent years' increases, because it's a cumulative thing, but...
We don't know that, but we do. If we look at page 21, he was in debit, according to that, by $954 on the 9th of June, 2006. And although I haven't done the maths, even if the premium had stayed at $74 rather than going up to 86, it seems tolerably clear that he would have been in minus for long enough for the policy to lapse. I'm not sure any of this really matters, because what matters is whether they're entitled to impose 75% uplift. And at the moment, I don't know where that came from in the contract.
No.
But it seems hard for you to argue that the judge wasn't entitled to find that the policy lapsed in 2000, lapsed by 2006.
That is my submission. But if I am wrong in relation to that, then of course I fall back on the argument that you may be able to prove lapse in relation by looking at a ledger. You can't prove reinstatement in accordance with a procedure in a policy by looking at a ledger. It needs more, and in particular in this case, it would need for the insurance company to succeed on the 75%, which at the end of the day they say comes because of, they're entitled to it because they've reinstated the policy, for Mr. McPhee to actually agree.
Well, we get back to paragraph 10 of the statement of claim. If it ever lapsed, he had it reinstated. I mean, he wasn't putting in issue the mechanism by which reinstatement was achieved. As Lord Legate says, it's very difficult for us to go behind paragraph 20 in the first instance judge's judgment that there was a lapse and a reinstatement on a number of occasions. But the perhaps more interesting question from the point of view of the appellant is, where did this 75% come from?
Well, indeed.
But I still don't understand if he had paid in these figures, these large premiums on 21st of June, and then another premium on the 1st of August, and the one on the 3rd of October. Suppose then he had died and his estate or whatever had claimed the $150,000. Are you saying that the insurer could say, no, this policy lapsed because we didn't institute the procedure for reinstatement? I don't think that would have gone
my lady. My point is that simply because an insurance company accepts payment, it doesn't mean that the policy is being reinstated in accordance with a specific procedure in a policy.
Well, what it means is they've waived the requirement for produced evidence, and they've waived the requirement to provide 3 months in advance.
Yes, and if they waive that requirement, then of course, on what basis do they turn around and say we're imposing 75%? Because the only way that it works is we're reinstating, but we're only reinstating on condition that you agree to pay 75%. And that's the lacuna in the evidence in this case. There's just no evidence that he ever agreed to the 75%.
Well, before you get to the evidence, there's the question of whether there's any contractual entitlement to impose 75% in the first place.
And nowhere in the contract does it in fact say that they were entitled. And my lord,
well, it does say any additional company requirements,
yes,
in effect on the date of the application for reinstatement, but I don't know where we find those additional company requirements that were in effect.
Of course, and in a contract that it needs to have a high level of transparency, because you've got an investment element, and for that investment element to be maintained, the insured needs to know how he has to increase his premiums in order to be able to maintain the investment value. One would have thought that...
Well, he needs to know whether to decide to reinstate or not, and he can't know that unless he knows what he has to do.
Exactly, but he needs to agree. There has to be, this is Contract 101, he needs to agree, and there's nowhere in the evidence. And it was never, it was never put to Mr. McPhee. Well, in 2006, and I take my Lord's point about the pleadings, but let's assume, arguing against myself, that there was a reinstatement. And what does that mean in the way that the insurance company means it? The insurance companies say, well, at the point at which we reinstated, this was a condition of reinstatement, we impose that 75%. But Mr. McPhee's got to agree to that. And Mr. McPhee was never cross-examined, and Mr. McPhee was never asked, well, Mr. McPhee, you agreed, didn't you?
Well, like that case, as I understand it, is he did agree when he signed a contract, because they interpret that clause as giving them the right to do anything they like. But that's a question of construction.
Yes, but well, it's a question of construction, but even let's assume that their construction of this is correct. Let's assume that it's correct.
Well, their construction, I understand it, is that they can, without telling him that he has to pay an additional premium, just levy one, even though they haven't got any published rule to that effect, but they can just decide to do that. That's their construction.
Yes,
if it's correct, then they win.
Yes, but that can't be right.
Well, that's another point, which, to my mind, you ought to be focusing on.
Yes, well, that can't be right, because that can't be right, because the
page 498 is the relevant clause. That's the construction of that clause. And
this is a point of law which you can take rather than arguing about what the evidence was and what was put in cross-examination.
And they're relying upon subparagraph 5 and, in effect, arbitrarily to impose anything they wish to. That's potentially what they are saying the subparagraph 5 means.
So 498.
Well, I'm not sure about that, because it's any additional company requirements in effect on the date of the application.
Yes.
There must be a pre-existing requirement somewhere in the company documentation which lets them impose it.
Yeah.
But none was disclosed.
I don't think they alleged that there was one, actually. They just, as far as I read their pleading, they just say they applied a rating of 75%. They don't actually plead that there was a company requirement.
And there was never any evidence in relation to this at all.
No.
But let's assume, let's assume, my lords, that even if it did, how is it that Mr. McPhee is then alleged to have agreed to the 75%? Because it's got to be communicated to Mr. McPhee. No letter that's been disclosed from the insurance company saying, Mr. McPhee, you are now required under clause 5 to pay 75% more. Because Mr. McPhee at that stage could have then decided, well, look, this is too steep. I'm sorry, but I'm not prepared to pay it.
Well, that goes, to my mind, to the construction of the clause, which it must be, when it says in effect, a reasonable person would read that as meaning that it's been communicated to the insured so he knows what he needs to do to reinstate.
Either you've got the requirements that are transparent, in this case they weren't transparent, pre this happening, so the insured actually knows because it's already been communicated somehow pre this happening, or alternatively, it takes place afterwards, but it's communicated upon the reinstatement. So it's in fact a condition of reinstatement. Well, you agree to pay. Mr. McPhee says, well, yes, I agree, but there's no evidence at all, and it was never put to Mr. McPhee in cross-examination. It's
a requirement, not in effect at the date of the application, not a requirement imposed in response to the application. So,
what I read this as meaning is that if you apply to reinstate your lapsed policy, then you are treated in effect as if you were a new customer, and you have to meet whatever requirements now, as at the date of reinstatement, apply to new customers, even if those didn't apply when the policy was first taken out. And that would include the premium that you would, in your current state, have to pay if you were applying for insurance now, given that A, you are that much older, and B, your credit record is a bit lamentable. But I think you would still say, if that translates into an uplift of 75% on something we're not quite sure what, that has to be told to him.
Yes. There has to be some communication at some point, and there was none in this particular case. I mean, At the very least, there ought to have been a letter to Mr. McPhee. So, Mr. McPhee, we are now at this stage charging that extra 75%, and there wasn't at all.
Yes, in the context that we're talking about a guaranteed cost of insurance, if you were to impose a completely different cost of insurance, you would have thought you might need a new table setting out how the cost each year would go up, because that's what the insurance company is promising it will do. I mean, there's none of that.
None of that. None of that. None of that. None of that.
I mean, my provisional reading of it, we haven't heard the respondent yet, is that you've got a right to reinstate within 3 years and go back to the guaranteed cost that this policy offers. Otherwise, you could simply take out a new policy anyway at the current rate.
What they're saying is that they were entitled to charge us 75%, but even if that is correct, as these requirements, even if that's correct, it's got to be communicated and McPhee got to agree. That's the reality, and there's no evidence of that at all. No cross-examination, no evidence led at all. Now, my lords, I don't want to labour the point in relation to this, and in fact it came after what my submissions on the guaranteed cost of insurance. But can I come back to the guaranteed cost of insurance, the annual increases? Because my lords must not assume that we're focusing on 75, that I accept that these annual increases were justified. Now, I just want to take my lords.
I'm sorry for interrupting, but as far as I see it, this insurance policy has a saving element. And in effect, the insurance company is in the same position as a bank or a building society. It is holding the money. It's not holding the money. The proprietary interest in the money passes to the insurance company, who then owes a debt to the insurer. And they're entitled to reduce that debt by agreed amounts in the contract. And again, it comes back to where the burden of proof lies. That is, do you have to establish that there's been a breach of contract, or does the bank have to establish that they have a contractual justification for reducing the size of the debt they owed your client? And that's the area that I would be particularly interested in.
My lord, in my submission, of course, my client has the burden of proof of proving a breach of contract. There's no doubt about that. My client says, well, here's the contract, this is what it says, these are the guaranteed costs of insurance under the contract, this is what should have been deducted, this is what was deducted. If the insurance company then comes to court and says, we were entitled to make those extra deductions because we had a contractual right to deduct 75%. It's for the insurance company to prove that. They bear the evidential burden in relation to that. And that includes the burden of taking your lordships to the contract and saying, well, this is actually how it's done. And this is the position.
Well, they would have an obligation to plead it. They would have an obligation to give discovery in relation to it. And then they would have an obligation to prove it.
And also, but returning to the guaranteed cost of insurance, if I may just make this point, that the policy illustration just simply did not assist at all in relation to how the guaranteed cost of insurance was going to be calculated. But the Court of Appeal also, there was exchanges with Mr. North that I'd like to take your lordships to, and that's at 357. At line 18 to 357, line 13. So my understanding is, I can only tell you what my understanding is based on the evidence given by Sheplani, there would be a definite amounts during the term of the policy for year 1, year 2, year 3, year 4. But there would be those, but where would those be determined? They were supposed to be in the policy illustration form. They were supposed to be there. Are they there? I don't see them. Therefore, the policy illustration on which you seek to rely as parole evidence is defective in that sense. It's defective once again. So there is a problem. Yes, right. And it does not help with the calculation. It doesn't. Okay, I'm willing to concede that. Now, if I may now take your lordship to the question of the tables and the evidence in relation to the tables.
Is this the table that should have been attached to the policy?
Yes. The starting point is let me take your lordships to 535 and just remind your lordships that there was a request at 535 for disclosure of the table of guaranteed cost of insurance in a letter of the 8th of September 2014. Paragraph 4, kindly provide the table of guaranteed cost of insurance charges. And there was never any response to that, no provision of the table in response to that letter from solicitors for Mr. McPhee. At page 43 of the bundle, your lordships will find at the bottom of page 43, paragraph 60, and this is the skeleton argument for the trial. The defendant still maintains its fundamental fraudulent assertion, which is a gravamen of its corporate position. The guaranteed cost of insurance was provided a renewable term was therefore subject to an increase every year per 1,000 of insurance coverage. No formula is provided to calculate those increases. So the submission was made. There's no formula to increase guaranteed cost of insurance. And over the page at the very top, the defendant it is submitted has interpreted that to mean the guaranteed cost of insurance and unilaterally imposed mortality charges can be increased and deducted arbitrarily. So there are 2 points that are being made in these paragraphs. No formula provided to calculate, and they are being increased and deducted arbitrarily. Now, I've already said that Mr. McPhee was not cross-examined on the table. It was never put to Mr. McPhee. Mr. McPhee, you received the table. Mr. McPhee, you knew what these charges were going to be. None of that, no cross-examination of any sort of that sort. If I can invite now your lordships to turn to page 103, and this is the cross-examination by Mr. McPhee and Ms. Chatlani. And this is why I say that she is given an opportunity to say the rates are the same as the table. So the guaranteed cost of insurance from the policy page, well, in fact, we'll pick it up at 13, line 13. That figure there, 7462, that's supposed to change according to the cost of insurance options, yes. How do you calculate that? How do you calculate the change? Okay, so you change it the next year, the guaranteed cost of insurance, it increases annually. It goes from 894. It goes next year to 963, yes. How do you calculate that? We have a schedule of rates, so per calculation I can't say. There are schedule of rates that are typical of a particular risk class, whether it be male, smoker, non-smoker, etc. Now, pausing there, that schedule of rates was never disclosed to the court. But she does not say, my lord, she does not say, and it would have been very easy for her to say, because she knew the terms of this contract, well, we applied the table. And then...
Well, she can't say, as I understand it, she didn't know. She was just giving evidence based on what records there were in front of her, wasn't she?
Yes, she...
Or was she the person who actually made decisions at the time.
Well, she was an
Yeah, she
action.
was.
She's not customer facing.
No.
She's not customer facing, and she comes to court and she says, "Well, we've applied rates that we have in our office."
And I don't think she was even working for the company at the time of the contract. So she's someone who's read the file.
Yes.
Yes.
Yes. And then at 505. So you're saying the guaranteed cost of insurance increases at the very top? Yes, it does annually, but you can't tell the court how it's calculated, how it's derived. I cannot.
What page is it, sorry?
Page 105 at the very top.
105.
So again, she couldn't say how it's being calculated. And 105 at, well, if we continue at 17, this insurance company, Colina Insurance,
Well, the answer from 9 to 16 is...
well, let's read from 9 until at the bottom 26. In the same way, you've accepted 74, what was initially proposed to you as the initial cost of insurance in the same manner in which that was derived. I can't get into that with you because it is a per risk class. I can't tell you how a number is calculated. It's determined actually, and it's in the same...
Probably actuarial.
Yes, probably.
Actuarially, yes. And it is the same across various policies of the same risk class at the same duration. Now, at this stage, Mr. McPhee then asks a pertinent question. This insurance company, Colina, purchased this insurance from another insurance company. You didn't write this. Yes. You purchased this policy. Yes. So the interpretation by you may be different from the interpretation from the original insurer. There are terms used in the insurance that are generic and are well understood, but with respect, the point is that essentially she can't really help with how it's calculated. She can't really help on what basis these rates have been agreed by Mr. McPhee. None of that evidence that one would expect would have been probative evidence.
I don't see how she could have said more than she said.
No.
She's saying the insurance premium goes up. It goes up, you look at the risk class of this particular insured person, and we have tables which show what the increase is. And of course, it's an arcane art, the art of the actuary, to work out what the increase is, or what the risk change is year on year, except as we know, the older you get, the more likely you are to die. But I didn't understand what he's actually asking her to say, to go into how actuaries work out what the risk is and how then the insurance company translates that into a percentage increase. That's...
Well, how is the increase calculated? He's a lay person, although he's a lawyer, but he's a litigant in person. He's not an insurance man, as the Court of Appeal observed.
He's a lawyer and a financial advisor.
He is, well, I don't know whether he's a financial advisor,
Well,
but he's
the paper
certainly...
suggests so. He holds himself out as such.
My Lord, I haven't seen that, I have to say, but...
I think the reference was a financial analyst.
Analyst, yeah.
I see, sorry.
Yeah.
I apologise.
The contract must be
Apologies, my
the
lord.
same, however expert or what he...
But I understood your point is that there was no evidence that the rates applied were those in a
Yes.
table attached to his policy.
Yes.
They could have been what were the current rates, and they could have gone up over time
Yes.
for new policies, and
Yes.
they could have been those rates applied. Or
Yes, and this is not a contract which provides, that says the rates, the guaranteed cost of insurance will increase with rates that we have applicable.
no, because it's a guaranteed cost.
It's a guaranteed cost, exactly. So if it's a guaranteed cost, you've got to demonstrate that that what you're applying has been agreed, and that is the chasm, not a lacuna, but the chasm in the evidence, that the evidential hole in the insurance company's case in relation to this. And it just seems to have been assumed by the judge that because this policy envisaged that the guaranteed cost of insurance, the cost of insurance would go up, that was sufficient for the insurance company to get home. And I say that with respect is wrong.
Well, I wonder about that. I mean, Ms. Satlani is saying that they operated according to a schedule related to risk class, and presumably the judge is inferring that the table attached to the policy at some stage would have been a risk class table. And we have contemporary documents. We have documents based on presumably contemporary documents listing an account listing when monies came out, monies came in, and there's no reason to believe that this was created after the event applying different rates. Isn't the judge entitled to infer that in a contract which envisaged annual increases, that the insurance company had applied the annual increases, absent any suggestion that they hadn't?
No.
Where we see the annual increase going up normally by between 7 and 10%.
No, my lord. My lord, different insurance companies may apply different rates in relation to...
This company applied its rates.
Yes. This company bought an insurance policy from another insurance company. That policy should have had a table. It didn't. That's the table that should have informed everybody that should have set out the guaranteed cost. This insurance company then applies rates. It's for this insurance company to come to court and to say, actually, yes, these are the rates in the table, because ultimately, what we are talking about here is, did Mr. McPhee agree to these rates? We're not talking about whether it was reasonable for the insurance company to impose these rates, whether the rates are within a range of reasonable rates that are imposed in the market, despite the fact there wasn't any evidence of that. So the question here is, how does Mr. McPhee agree? That's the point.
To an extent, I'm grateful to be taken to the evidence, but I was more interested in the findings of the trial judge.
Right.
And if I can just take you to two findings. Page 196, paragraph 58. And this is describing Ms. Shatlani's evidence. And a clear finding, she was unable to say by how much. So the judge summarizes, stated that according to the policy agreement, this figure increases annually, 1,000 of coverage, but she was unable to say by how much. And she then, she however stated that it increases depending on particular risk class, male, smoker, non-smoker, female smoker, non-smoker, and the person's age. Well, your case is it depends upon the table. It doesn't depend upon the risk class. The risk class is set at the very start. And then you go to page 202, paragraph 82, and there the judge makes a finding that the rate of increase is unknown.
Yes.
But then goes on to accept the explanation given by Ms. Chatlani that such an increase is based on the person's age and the risk associated with age. And I assume it's your case that it should be based on the basis of the agreed rates contained in the table.
Absolutely. That in a nutshell is my case, yes.
But we don't know whether the table was the same as that.
Yeah.
No, and you say it's for the insurer to show that
Exactly.
those are the rates applied.
And the insurer says it's for you to show.
Yes.
So,
But you see, he was never, in this particular case, Mr. McPhee was never cross-examined and said, okay, the table, and you knew what the table, and no cross-examination in relation to the table. And the reason why I infer that he was never cross-examined in relation to that was because the insurance company never in fact applied the rates in the table. They had their own rates and they applied their own rates. That's the reason. Otherwise, Otherwise, if there had been evidence that the rates were the table...
You are raising a whole new point, which is the transition of this policy from the original insured to this insured, and now you're suggesting something went wrong, they just applied their own rates, but nobody's ever said there was any significance to the fact that Colina were not the originators of this policy. It seems to me you're now trying to introduce some new factor which nobody has referred to before, of there being some significance from which we can draw an inference that although they took over the policy, they actually applied different rates from the rates that would have been applied if it had stayed with the originally insured. And I don't see the basis to now enter into that kind of...
No, I don't seek to draw an inference from the changeover.
That you infer that when Colina took this over, they just started applying their own rates rather than the contractual rates under the policy that they took over, and that seems to me a brand new point.
Yes.
My lady, it is indisputable in my submission that Colina applies its own rates. They say, we've applied a schedule of rates in our office. That was the evidence.
We have no idea whether that's the same rate that they apply to new customers or whether it's a special rate that they apply to these legacy policies from...
But that is precisely the point. We have no idea.
And that's a better point, it seems to me, rather than speculate what rates were applied, is to say it was simply never shown what the rates were.
That's a totally different point, because, I mean, for all we know, Colina bought this portfolio of policies from Canada Life, and they may have inherited their schedule of rates from Canada Life. We simply don't know.
Of course we don't know.
And certainly for a second court of appeal to make the inference that you invite, I think is ambitious.
The witness didn't know for Colina. That was what she said, wasn't it? She didn't know how they've been, what the rates were.
No, but it's the obligation of the insurance company to come to court and to say, well, we imposed the rates in accordance with the contract.
Yeah, well, that's your fundamental argument.
Point.
Yes, that's my fundamental point, of course. That is my fundamental point.
And that applies, you say, both to the increase, the annual increase, and to this mysterious 75% of something uplift.
Yes. And if I take my lady...
There must be law. We've got building societies and banks and so on. There must be law on as to who has the burden of proof.
My lord, I am not aware. I can only repeat the submission that I made to your lordship, that they bear the evidential burden, which they have singularly failed to discharge in my respectful submission. Okay. Now, the Court of Appeal actually get it very badly wrong. May I just take your lordships to page 429? So they rightly set out the grounds of appeal at 3, at the top. So the learned judge was in error in the meaning and application of yearly renewable rate with respect to basic cost of insurance and guaranteed cost of insurance. The learned judge held that yearly renewable rate must mean the rate would change yearly. However, the rate of increase is unknown. So that's the point that was being made by Mr. McPhee in the Court of Appeal. And there are many exchanges in relation to this. And then at 8, the Court of Appeal say, well, at the hearing, the appellant reduced his grounds to 2 issues. Could the respondent contractually increase both the GCOI and the premium payment after several lapses and subsequent reinstatements of the policy by the appellant? Now, this is a complete conflation of 2 issues here in my submission, because the the guaranteed cost of insurance does not go up in reinstatement. It has nothing to do with reinstatement. Reinstatement is only relevant to the 75%. The guaranteed cost of insurance goes up annually and has really nothing to do with lapses and reinstatement. And having asked the wrong question to start off with, we then get the wrong answer at paragraph 17. As he goes through what the judge held in terms of the yearly renewable rate, paragraph 16 and at 17, from this excerpt, the trial judge considered the ordinary and natural meaning of the words used in the policy contract, together with the evidence from the witnesses in coming to her conclusion. Based on what was before her, she was entitled to take the view the policy contract gave the respondent the power to increase the premium payment and the guaranteed cost of insurance when the policy lapsed, and the appellant applied for reinstatement. There is no merit in this ground of appeal. But of course, from paragraphs 9 all the way to paragraph 16, what is being dealt with here is not the 75%. What's being dealt with is the guaranteed cost of insurance. It's the annual increases. And I just haven't been able to get my mind around why the Court of Appeal approaches this in the way that they do. And it cannot be said that Mr. McPhee misled the Court of Appeal, because if I take your lordships to 312, line 1, Crane Scott JA, so your main argument then, right, because the issues of lapsing come later. Their view, as I understand it, their view of how this policy is to be administered and how the cost of insurance and so on, their view as to this renewable cost of insurance thing, guaranteed cost of insurance, and how this is to be calculated is completely different from how you see it. You see it as the 82 whatever, they see it as a bigger figure that ultimately reduces whatever available to you in your insurance, exactly. And then at the bottom, so your main point really in this appeal is whether in fact, as you allege, the respondent did not calculate the investment account value according to the policy terms. You say they should only have used the figure 82. They feel they can do more because it increases every year according to 1,000 per whatever. That's the reference to the policy illustration document. Is that, in a nutshell, what this appeal, Mr. McPhee, their number, has fabricated? The issue of lapsing and definition of life insured, all of that is completely peripheral to this. Yes, that's right. Now,
this is all about whether or not the contract envisaged annual increases at all. But that's not really the nature of your appeal now. The nature of your appeal now is that you are tacitly accepting that the GCOI may have been able to be increased annually as the risk increased, but that there has been a failure by the insurance company, on whom you say the evidential burden lies, to prove that these figures were contractually based.
Yes, we're agreed, indeed. And of course, all in the context, my lord, this is not Mr. McPhee attempting to pull a fast one, so to speak. Mr. McPhee has taken a position, he's taken a view consistent on what this contract actually meant. So, and he has taken the view, well, if we look at the cover sheet in the insurance policy, it says yearly renewable rate, $74 spot something, a duration lifetime. So he's taken the view, well, it's not going to increase. Now, if he's wrong about that, then it's got to increase in accordance with the table.
Is that the default position? I mean, there's a lot of law about uncertainty of contractual terms and what the effect of that is on the existence of the contract. You seem to be assuming that if you're right, that there was no, although the contract does provide for an annual increase in the the general cost, the rate of increase was too uncertain. But is the result of that, as you say, well, then they're stuck with the $74, or is it that the court implies a reasonable increase, and what would that be? Or is it that the whole contract fails and there never was a contract? I mean, there's a lot of law which I know my Lord Legate has contributed as to what is the result. From what I recall, the courts have always striven to give some meaning to terms in a contract, even if they're a bit uncertain, once the parties have both acted on the existence of the contract. But I don't think you can assume that if you're right that it's all too uncertain, then great, there's just no increase, because I don't think the insurer would have agreed to that.
My lady, it can't be the second option that my lady posited, because there would have had to be evidence at trial by experts saying what would have been reasonable and what was reasonable.
It wasn't expert evidence because nobody was asserting this.
No, my lady, Mr. McPhee was from the very beginning asserting you weren't entitled to increase my guaranteed cost of insurance. That's his base position. However one cuts it, that's his base position. The insurance company says, well, we were, because the contract envisaged an increase, we've applied this schedule. The insurance company is right. It has to be, on any view, it has to be the table. You've got to have a bridge, an evidential bridge, between the rates that they applied and the table. If the insurance company has singularly failed to discharge that evidential burden that Mr. McPhee has agreed to their rates, then essentially we fall back on the fact that there is an amount of the cost of insurance that's set out in the contract. That's 74 spot, I think it is 62 from memory, and that's the cost, and that is what remains static.
But on this assumption, that's not the cost, because the cost was supposed to go up. But what is the legal effect if there is a defect in the contract that it's not sufficiently clear? I don't at the moment accept that you can just say, well, that means that they're stuck with the $74, because that's not what either party intended when they entered into the contract. If you're wrong on your first point. But this wasn't explored at the hearing or in the previous, because this was not how the case was being put.
No, it wasn't. But in that situation, in my responsible submission, the right order is for the board to remit it back. It's not the board. The board is in a difficult situation here, because if at the end of the day the board accepts my submission that they've imposed this rate, that it's not the table, there's no evidence that it's the table, and therefore that Mr. McPhee has agreed to those rates, how is the board then to take the decision to say, well, it's all okay because these rates were rates that applied to this particular class?
You have two different points, as I said at the beginning. Your first point is not proved that there ever was a table, and if you're right about that, then we get to my Lady Rose's question. Does that mean that the rate stays at 74? Does it mean you interpret it as though there's some sort of hypothetical table? Or does it mean that there's no binding contract? But then your second point is, even if there was a table, they failed to prove what the amounts are, and unless you can prove a specific amount, you haven't shown your entitlement to deduct that amount. And all they have shown is that the amount was no less than 74, because it could only be so 74 is the minimum they've shown they're entitled to deduct. That's your second argument.
My Lord, yes. Now, my Lord, there was never any, in my responsible submission, there's never any finding of fact that's been made by the judge either that Mr. McPhee agreed to the increases. In fact, we've read the judgment of the learned judge and those relevant paragraphs, and so there's no finding of fact, there's no concurrent finding of fact in relation to that. And there's also likewise no finding of fact by the judge in relation to the 75%, that Mr. McPhee agreed to that 75%. The judge doesn't really grapple with any of the issues of construction that we have been addressing in the course of this.
I can see the force of that in relation to the 75%. But in relation to the question, did he agree a contract which envisaged annual increases in the guaranteed cost of insurance, then that's simply a matter of interpreting what the contract says, because he signed that contract. And to my mind, the contract did envisage annual increases. Your point, which may be the better point, is that it hasn't been proved what those authorised increases were.
And she makes no finding, in actual fact. That's another point that I make. She makes no finding that he has agreed to those specific rates. I have not been able to see anything in the judgment in relation to that.
But is that purely on the basis that the table was not provided, or it hasn't been proved that the table was provided? Do you accept that if the table was provided, then this point would fall away?
I accept that if the table had been provided, then of course that part of the appeal would fall away, because the...
So which part of the appeal is that? Sorry.
On the guaranteed cost of insurance, not the 75%.
Well, you still have the point that they haven't proved what was in the table.
Well,
but
exactly.
There's the first of the 2 points I made. The first one is, did the contract, which we have to construe, include a table, or did it not, and who has the burden of proof? And then there's a second and separate point. If it did include a table, was the insurer entitled, has it made out, you say the burden being on it, that it was entitled to deduct the amounts that it did deduct? And you say no, because there was no finding that those amounts corresponded to the amounts in the table.
Indeed. And in the Court of Appeal, there is an extract that I do want to refer your Lordships to. I may have a moment, because I've taken my submissions out of zinc, but... Well, Mr. McPhee is asked about the question of the table, and he says, yes, it's at 257, 17 to 25. So, Crates JA, he asks about the table, and he says the guaranteed cost of insurance that is mentioned on page 13 of tab 3, monthly guaranteed cost of insurance is 1/12 of the table. Where is it? Okay, now the policy did not include tables. That is a fact, that is a fact, that is a fact. Mr. North doesn't stand up and say, there was a table, here's the table.
Well, he doesn't have to stand up. The question is, what did the judge find?
The judge, in my respectful submission, makes no finding in relation to the table. Doesn't find that there is or there isn't a table.
The judge appears to have assumed, inferred from the historic records, that there was regular, other than 2006, that there were regular annual increases of a fairly constant percentage, and she seems to have been willing to infer that was in all probability what the contract allowed, and she may be entitled so to infer.
And that Mr. McPhee received those annual statements. I think she also finds that he received those annual statements.
And she received annual statements, yes.
Which I think he denied, didn't he?
He denied it, and I emphasise the point that I've made in relation to those tables at the very beginning, the annual statements. He was not cross-examined. Nobody said to him, my lady, it's a fundamental point. There's authority on this going back many years. I think the rule is Brown versus Dunn, it's a House of Lords authority, late 19th century. You want to rely on evidence to contradict what somebody says in direct oral testimony, you've got to put that evidence. And there was never any cross-examination of Mr. McPhee that he had received the tables, and therefore...
Statements, you mean?
The statements, sorry, not the tables, the statements, and therefore you get to a situation where his evidence is unchallenged in relation to this. On the judgment, if I may just very briefly, because there are two further paragraphs that we didn't...
But I'd like to know what your case is. Is your case that there never was a table, and therefore the contract is uncertain in some way, or is it your case that there was a table but it hasn't been applied?
No.
Not shown to have been applied.
Not shown to be applied.
No, my lord. Mr. McPhee's case, and indeed the contracts that were disclosed, did not include a table. Mr. McPhee says the contract did not include a table. That's his case. The solicitors asked for the table. The table was never produced. There was never a table before the judge at the trial.
Yes, and this is a lacuna, you say, because the cost of insurance was guaranteed. And when I read the papers, I asked myself, well, what is being guaranteed? And it must have been the cost as stated in the table.
Absolutely, and that's the only way that this policy works, because it's got an investment value. And for him to know, well, if my cost is going to go up in this particular way, I've got to keep my premiums at a particular level in order to maintain the investment value.
Well, the point of having it guaranteed is otherwise you might just as well go out and buy a new life cover every year, but you want to be locked in at the beginning into a fixed, fixed rates, albeit gradually ascending.
Just finally, my lords, on the judgment, there's just two paragraphs that it's paragraph 58 and 59.
This is of the first
of the first instance. Yes, this we. My lords, I've taken my lords to this, to 58 and 59, and then there is also 63 to 65. And that's where she deals with guaranteed cost of insurance. But of course, nowhere does she actually grapple with the point that we are making in this appeal, which is how it is suggested that Mr. McPhee agreed to these rates. And therefore this is not a case in my submission where the judge actually makes a concurrent finding of fact.
But he did sign the policy. He applied for the policy and he signed that. And the question is, what was he signifying by that signature? If he sees that there should be a table, he sees that there's no table attached to what's been sent to him, he thinks to himself, well, I won't ask for the table, because if they don't provide me with the table, then at some later date, I'm not saying this is Mr. McPhee's mind, but a potential insured, if they haven't sent me the table, then I'm not going to pay. I'm not agreeing to any increases.
None of that was ever put to Mr. McPhee, but Mr. McPhee.
I'm just trying to work out what the legal effect of your case is, regardless of what was actually put to him or not. If an insurer omits to send a table which should be attached to a policy to the insured doesn't ask for that, it's never provided, does that then mean that the insured is not agreeing to any increase in the... And for how long? Forever? Does that mean that they can just keep paying the same premium?
My lady, the problem, of course, with this case is that Mr. McPhee interprets the contract as meaning that that the cost of insurance remains the same. He then thinks that the guaranteed cost of insurance, that's his evidence, the guaranteed cost of insurance and the table, that's relevant if, for example, he decided to increase cover by another £10,000, that in that kind of situation, the table would then show by how much the insurance would, cost of insurance would actually go up. That's the reason why, in his mind, the table is never relevant. But what we are saying of this appeal is that the insurance company always bore the burden of saying, we've increased these charges annually in accordance with this table. Not only has the table never ever been produced, not even when the solicitors asked for it in 2014.
Well, what difference would that make? Suppose they had provided it in 2014. How can that make it?
Well, then we could see whether the charges reflected it or whether they didn't.
Well, yes, but it wouldn't show that it had been provided at the time. What I'm exploring is whether you're asking us to decide that even though both parties, on this hypothesis, even though both parties intend that the rate, the cost of the insurance policy will increase over the years, if they don't provide the table which they say they're going to provide with the policy showing out the mechanism, then they are stuck with a policy which they have to honour at a cost which does not increase over the remaining life of the insured.
Yes.
That's what you're asking us to hold.
Yes. Very simply, it's not sufficient for the insurance company to show, well, the contract envisaged potentially an increase. Look, if the contract had envisaged an increase and the contract had said, and the insurance company will apply the rates applicable from time to time, well, fine. But that was not the position in this insurance policy. This insurance policy provided for the cost of insurance to go up, and it was guaranteed in accordance with a table that's not been produced, and indeed...
Yes, but this is a very different case from that presented by Mr. McPhee at first instance. Mr. McPhee's case at first instance with this contract did not allow increases, and the issue as to whether the table was produced or not was really neither here nor there. It is a considerable development of his case now for it to turn on whether or not the judge was right to infer, having concluded that the contract did allow annual increases in charges because it was the very nature of the contract, and having evidence that with the exception of 2006 the costs increased at a moderate level each year, to infer that the insurance company had failed to prove that they had applied the contract. That wasn't the case that Mr. McPhee was making.
No, the case that Mr. McPhee was making, in a moment I'll just confer with my junior who wants to say something, was that they were not entitled to increase it. Yes, absolutely, they were not entitled to increase it. But in showing that they were entitled, they've also got to show that the rates that they applied were contractually based. And we say they've not. And we say they've not.
No, it's even more than that. You have to, even though they could show that there was a table, and they've applied the rates of increase in that table, I think you say, too bad, if you didn't send him the table, then there is uncertainty in the contract as to the mechanism.
Well, it was never part of the contract.
Never part of the contract, yeah. May I have a moment, please? Yeah. May I take your lordships to page 555? Paragraph 21 of Mr. McPhee's witness statement.
Page
555.
And the opening sentence of paragraph 21 says the defendant has to explain how and under what provision in the contract the policy has lapsed, and how the increases in the guaranteed cost of insurance calculated and under what provision. And then at page 169, in the defendant's closing submissions, paragraph 8, it says, at paragraph 21 of his witness statement, Mr. McPhee insisted the defendant have to explain how and under what provision in the contract the policy has lapsed, and how were the increases in the guaranteed cost of insurance calculated and under what provision. So it's not true to say that these points were not up in the air. The reality is that it was for the insurance company to come to court and say, well, we've applied these rates, we've increased it in this way, and we're justified because of these terms in the contract. The terms must have been the table. My Lords, unless I can assist your Lordships any further with any other questions that your Lordships may have.
Well, can we take it that you're not pursuing the question of whether the policy lapsed in 2014?
Well, in fact, I got sidetracked in my original, introductory
Irrelevant to the question.
Well, what I was going to say is that I wasn't going to deal with that, and we've made submissions in the written case.
But what would it matter if it hadn't lapsed when he made the payment? What difference would that make now?
It would be a completely Pyrrhic victory if at the end of the day your Lordships were not with me on my other points, but then said, well, they weren't entitled because of this day.
What, in fact, difference would it make to anything?
It would make very little difference.
Not very little. Would it make any difference?
Well, the only difference that it would make would be that the policy had been.
So what? He would have had life cover for another month or something until he went into the red again or whatever, and as he didn't die during that period, there's no consequences.
He hasn't died. It seems to be of very little relevance to anything.
Thank God that he hasn't, yes, but he hasn't died.
But I mean, if he'd been carrying on, he would have been paying for life cover for the last 10 years, which wouldn't have been called on. So,
well, I suppose if he did die now,
he wouldn't have cover now unless he kept paying, unless he wants to pay all the back premiums.
Well, exactly. It would
which I'm assuming he doesn't.
What is it?
No, because he's disputing them.
Yeah.
No, but even if he, on any view, he doesn't want to. He doesn't want to make it up to date, does he? Reinstate it now.
This case is about him getting what he thinks was the investment value in his account.
That is what this case is about.
Yes.
Yeah.
And that is the point that I was going to make initially when I got sidetracked.
And point 3 really doesn't arise in that battle. Yes.
Even if I won, it would just really be.
So it's about something like $7,000 Bahamian dollars.
No. If I won on that point, but did not win on the other 2 points that I've been addressing, your Lordship,
It would have no financial.
It would have no financial consequence at all.
Yes. Okay. Okay. Yes. Okay. That's fine.
Well, those are my submissions.
Yes, I think it's worth it.
Thank you very much. The board will adjourn briefly to consider what matters they wish the respondents to address. Thank you. We do not need to hear you on the question as to whether this contract envisaged annual increases in the GCOI. The evidential matters are a different matter. We need to hear you on that. Similarly, we do not need to hear you on the question of whether there was a lapse and reinstatement back in 2006 or in accordance with the first instance judge's findings of fact that there were several lapses and reinstatements, nor do we need to hear you on the third ground of the 7th or 8th of September. Otherwise, we welcome such clarification as you can give. Thank you.
I'm very grateful, my Lord. My Lord, I was going to, my Lady, I was going to start, if I may, with the relevant context in which the contract is to be construed. And obviously a part of that now falls away because it was directed to the annual increases. But the context is still relevant to the remaining issues, going to the table and so on. And in terms of that relevant context, my Lord and my Lady will have seen from the agreed statement of facts that after an original policy had been issued by Canada Life Assurance Company in August 2003, the appellant applied for it to be converted to what is described as a universal life insurance policy. I'm not sure my learned friend mentioned the words universal life at all, but it is a standard product in the market and there are standard terms within that policy. So the appellant signed an application form on the 5th of September 2003 together with a policy illustration on that date. And again, I'm not sure my learned friend took your lordship to my lady to the policy illustration. But the policy illustration set out important information about the product the appellant was converting his original policy into. That's what it says. And I should like to start, if I may, with the application form, which is in the reproduced record of appeal, tab 21, page 483.
You needn't refer us to tab numbers because in the brave new world we now have, we only have these documents in, other than the basic bundle, in electronic form.
Sorry, could you give the number again?
483.
It's 483. What the board will see there is a one-page application form. It is on a Canada Life pro forma, headed application for reinstatement and or policy change, and records an application by the appellant to convert his policy to a universal life policy, or a universal life plan. You can see that in the middle towards the top of the page. And with a quarterly premium of $528 Bahamian dollars and 12 cents. And that form, as I say, was signed by the appellant on the 5th of September 2003. You can see that at the bottom. And the policy illustration, which is at page 473, was signed by the appellant on the same day. It is headed Universal Life on that first page, and indeed there are references to Universal Life appear throughout its 6 pages. There are 3 more on that first page, and there is one on page 474 in the first line on page 2 of the document, page 474 of the bundle. Canada Life's Universal Life combines the security of life insurance protection with a highly flexible savings component. And then the 2 sentences on, in that first paragraph, your insurance advisor can provide you with a detailed product description. This policy illustration summary describes the insurance protection that you have requested and must be reviewed with the policy illustration. And that policy illustration appears on pages 4 and 5 of the document, pages 476 and 479. I'm afraid, my lords, my lady, there are some duplicate pages in between. It's page 476 and 479 are the 2 pages of what's called the policy illustration. And I'll come back to the detail of that just in a few moments.
what essentially they show is that after the age of 65, the sums start declining.
Exactly, my lord. One of the points that was put in the written case by the appellant is that it was crucial for the board to understand that this was an investment. But what you can see from this policy illustration, if I take the point now, is that on the basis the appellant paid a target premium of $2,112 Bahamian dollars and 48 cents annually. By the age of 71, there would be no investment element left. And the only reason that can be the case, given that the premium is going to be paid constantly, that's the assumption made in this illustration, the premium is paid at a fixed rate. The only reason you see it going up and then coming down is because the cost of insurance starts low and increases high. And that's where we get to in terms of the policy illustration. But again, this is all talking about a universal life policy. And on page 6 of the document, 480 in the record, you can see the appellant's signature dated the 5th of September 2003 under the owner's statement. And the top of the page, owner's statement, in signing this illustration, I confirm that I have reviewed this entire illustration and has been explained to my satisfaction by my insurance advisor. That's a confirmation by the appellant at the top of the page, and you get the corresponding confirmation by the insurance advisor himself at the bottom of the page. Insurance advisor's statement in signing this illustration, I confirm I have reviewed this entire illustration and that I've explained it to the satisfaction of my client, and so on. So that was the basis, the application and the policy illustration containing those confirmations by the appellant and by his insurance advisor, that Canada Life accepted the appellant's application to convert his policy to a universal life insurance policy, and the basis on which the policy was issued to the appellant. And that is the policy under which the respondent assumes the obligations of insurer on the 1st of January 2004. Now, as we've observed in section B4 of our written case, universal life is not a name coined by Canada Life. It refers to an established standard form of life insurance, which was devised in the United States in the late 1970s as a more flexible alternative to traditional term and whole-of-life insurance policies. And although it's somewhat less well known in the United Kingdom, universal life policies have been the subject of extensive discussion in the courts in the United States and in insurance texts, some of which we referred to in our written case.
That may be of some interest, but ultimately of no relevance in interpreting this policy.
Well, my lord, it is relevant, we say. It is part of the context.
Well, there's no plea that there was some customary meaning to the terms or anything like that. Your client never made such a case.
Perhaps
I mean, I think one can understand what the policy is, how it's meant to work, although it's not well drafted from reading it. But all this reference to other cases and so on is not actually relevant to the interpretation of the policy.
At the end of the day, this court the board has indicated to you that it is accepting that the policy was intended to have the guaranteed cost of insurance increase in line with the risk that all of us face, that as we get older, the likelihood of us falling off the perch increases. And I think a lot of what you're addressing now is really addressing a topic on which the door has already been open for you.
I understand. Certainly that was the primary focus of why I started here with the context. But it's not just in relation to that issue, which I no longer need to address, and I'm not going to take the board's time up. The reason I started there is because these policies are standard form policies and are understood in the market. And it is a policy for which the appellant specifically applied to convert his original policy into And moreover, he did so with the benefit of advice and assistance and the assistance of an insurance consultant who himself was familiar with this type of policy. He is an operator in the market, and there was confirmation that these types of policies, in particular the terms, were explained to the appellant. So, my Lord Justice Leggett asked, what is the relevance of this? And it goes now to this question of the existence of the table. It is relevant to the likelihoods, the probabilities in relation to the existence of the table. The fact that the appellant, Mr. McPhee, had an insurance advisor is very material. An insurance consultant who is familiar with these types of policies and had explained them to the appellant, and therefore would have known and raised it, we would say, on the balance of probabilities if there had been an absence of a table when the policy was in the event issued.
Well, wait a minute. Let's be clear what we're talking. When you say that the table existed, I don't think the point is whether it was provided to Mr. McPhee, and if it wasn't, and who has to establish whether it was or it wasn't, and if it wasn't, what is the effect of that on the question of the enforceability of any increase in GCOR?
Yes, certainly. And so I'm addressing the first of those points, whether the likelihood of whether it was provided to Mr. McPhee. Right. And my submission is that the existence of an insurance advisor advising Mr. McPhee is material to that question, because the insurance consultant is familiar with these standard policies and would have, in all likelihood, noted the absence of a table if it had been absent. And that dovetails, in a sense, with the terms of the policy itself, insofar as it speaks to a table.
Well, are we to assume that your client had lost the table, or just chose not to produce it when asked?
Well, my Lord, in terms of the letter in 2014, I don't know why that wasn't responded. The letter was responded to. I don't know why the table wasn't produced in response to it.
Or in disclosure in the proceedings, for that matter.
My Lord, in relation to the disclosure in the proceedings, one has got to be very careful there, we would submit. And one has to look at the issues as they were defined before the court. And the issue that was before the court at first instance was whether there was any contractual entitlement to increase annually the cost of insurance.
Certainly, but also certainly an issue as to if there was, what was it? For the 75%, if nothing else.
Well, the 75% is obviously the one-off rating. The annual increases.
You can't say your client didn't need to, it wasn't relevant to show whether the table was part of the contract or not. It obviously was, in any event, as you accept, to the question of whether there were annual increases agreed.
Well, the table must be relevant to this extent that you were guaranteeing the cost of insurance. If, as the board accepts, that the contract envisages annual increases in the cost of insurance, then there must have been something produced to give content to the guarantee, to the assured, namely that this is what the person will be facing each year.
And indeed, if I could add to that, this is a fundamental document. This is the policy, and the entire policy should be discovered.
Well, certainly, I understand all those points. What I'm seeking to do is address them one by one. And
yes, of course.
The reason I started with the context and the insurance consultant is because the context, the relevant context, and what the standard form of these policies is because there is material before your lordships today which shows that the tables attached to these types of policies show the maximum rates that can be charged by an insurer. That is why it's a guaranteed cost of insurer. The guaranteed rates are those set out in the table. They are the maximum rates. And I was going to the materials in order to not, say, go to the increase, which they also show, but go to that understanding as to what the table at the end of the policy contained and would have been understood to have contained. And it's the first passage, I'm going to go to two passages because they've taken on an importance. But the first passage I was going to go to is an actuarial textbook.
You can't construe the contract from an actuarial textbook. You've got to look at what it says.
In its context.
Either it says it's a maximum or it says these are the costs. I mean, it says one or the other. It don't get the answer in an actuarial textbook.
No, of course not. Of course not. You don't. When you're construing this policy, you have to look at its words, but you have to look at them in their context.
Or was Mr. McPhee shown this actuarial textbook as part of the factual matrix?
No, but he took advice and had the benefit of the advice of an insurance consultant who was familiar with these types of policies.
Was it in evidence at the trial that this was understood market practice, this actuarial textbook?
Not the actuarial textbook, no. But
I would like you to take me to the textbook, thank you.
my Lord, I'm grateful. The actuarial textbook, the authorities are largely North American because this is a standard product seen in North America, but the actuarial textbook itself is in fact published by Cambridge University Press and the Institute of Faculty of Actuaries, which is the professional body that represents actuaries in the United Kingdom. And it's to be found at 1420. And at 1420, see it's got a catchy title, Actuarial Mathematics for Life Contingent Risks. And at 1421, it moves on in the book to a chapter headed Universal Life Insurance. And at 1422, it gives a description of universal life insurance and how it operates. And I don't need to go to that now. At 1423, there is also a definition of cost of insurance, which is the charge deducted from the policyholder's account balance to cover the cost of the additional death benefit. Additional because it's the death benefit insured, in this case 150,000, in addition to any account value. As the policyholder ages, the mortality charge per dollar of additional death benefit increases, so the cost of insurance can be interpreted as a single premium for a one-year term of insurance. And that is quite a helpful analogy, a comparison to be drawn to a one-year term of insurance. Since the cost of insurance increases with the age of the policyholder, with each year he gets older, the applicable rate for any particular year can be viewed as a single premium for a one-year term insurance. And so taken around accordingly, a universal life insurance policy can be viewed as a succession of one-year term insurances under which the cost of insurance increases each year in line with the policyholder's increasing age. But the particular passage, and I should say that over the page at 1424, just in passing, it also notes that there is an option to move to a level rate. But that point I don't need to go to. But the point that I am looking at and looking for here is at page 1440 in the textbook.
And the electronic page number, sorry?
1440, sorry, is the electronic number. It's of the bundle. It should be page 564 of the textbook.
Yeah.
Forgive me.
Thank you very much indeed. Thank you.
At the top of the page, perhaps I should just start on the previous page just to pick up exactly what it's saying. 1439. The worked examples in this chapter are simplified to provide a better illustration of the key features of a universal life contract. In particular, we have not addressed the fact that the expense charges, COI, and credit interest are changeable at the discretion of the insurer. However, there will be maximum guaranteed rates set out at issue for expense and COI charges and the maximum guaranteed credited interest rates. So there are maximum rates set out is what this say, help.
Well, that may be what the textbook says, but what the policy says is that those were the rates. Not just maximum, those were the agreed rates.
Absolutely, my lord. Those were the guaranteed rates. And my submission to your lordship is the word guaranteed on its proper construction, in its proper context, means a maximum rate. It's guaranteed not to go above that rate, as set out in the table. It can be less than that.
Well, you mean the insurer might just decide to charge less than the rate amount on the table?
Yes, and that is what a number of the US cases show happens. There is a maximum rate that's set out on the table, but the actual rate charged may well be, and often is less, depending upon the insurer's assessment of what's called the mortality risk. Because those standard form tables can change from period to period, and there was a change in the standard mortality risk, reflecting the fact that as a population we get older. So maximum rates are set out at the beginning, because of course these are long-term contracts, and if the mortality risk assessment changes, a lower rate can be charged as you go along. And we get that indication towards maximum rates also, if I may just briefly indulge the board, from a textbook describing these policies. It's a US textbook on life insurance by Black and Skipper, which starts at page 1411, then the next page in the bundle. This is a textbook that's been cited in US cases, and it gives a detailed explanation of universal life insurance, starting on page 1442. And again, it explains the nature of universal life insurance policies 1444, that they're transparent, they're unbundled. But the point I need to go to this textbook for now, again, is 1446, the bottom of the left-hand column. It says next in the last paragraph on that left-hand column, mortality charges are based upon the insured's attained age and the policy's net amount at risk, and charges for any supplemental benefits, e.g. premium waiver, would be subtracted. So mortality charges would be subtracted from the balance of the investment account. The mortality charges are usually indeterminate, with the actual charge usually being less than the stated maximum rate contained within the policy, usually being less than the stated maximum rate contained in the policy. And similarly at page 1450, under the heading mortality charges at the bottom of the right-hand column.
The last page, I'm so sorry.
1450.
450, mortality charges, yes, thank you.
So this book is going through each element of the standard features of a universal life policy. It's looked at premium payments and policy loadings, and now it's looking at specifically mortality charges. And it says each month mortality charges are deducted from UL, it's Universal Life cash values. That's from the investment account or the cash reserve, or whichever term is being used. The total monthly mortality charge is derived by multiplying the applicable rate by the policy's NAR. The maximum rates per 100,000 are stated in the contract for all ages, and actual rates charged are guaranteed never to exceed those maximums. So my submission, my lords, is the table contains maximum rates. And
Well, how do you reconcile that with what the policy says?
The reason I say that is as a matter of construction. Policy uses the language guaranteed costs of insurance. And my lords, you ask what is guaranteed? And what is guaranteed in this market is understood to be that the rates being charged will not exceed those maximum rates stated in the table. So,
Well, on page 493 of the bundle, there's a definition in the policy of guaranteed cost of insurance,
yes,
and it says the deduction from the account value used to pay for the insurance under this policy. And so it's the amount of the deduction.
yes.
So that's not a maximum, it's the amount deducted.
But
Agreed to be deducted.
it is the amount that can be deducted, and my submission is that looked at in the round, the reason the word guaranteed cost of insurance is used, the word guaranteed is used, is because those are maximum amounts. Otherwise, this policy could simply have said the cost of insurance.
No, it couldn't, because the rates might change from time to time. If I take out a policy this year, what I'd have to pay at the age of 71 might be different from if I take it out in 5 years' time. And I take guaranteed to mean that you are guaranteed that the rates will follow the table with the policy, even though the insurer's own current rates for somebody your age may change over time. So you know what you're going to pay each year. Otherwise, you might as well just buy annual life insurance from year to year and have a savings plan at the same time.
And my lord, that's right in certainly in this sense. And what the Court of Appeal, the Commonwealth of Bahamas in this case, took on board was a definition of yearly renewable rate in a dictionary of insurance terms. And that was at paragraph 15 of the Court of Appeal judgment, which appears at 431 to 432, where the Honourable Mr. Justice Jones, delivering the judgment of the Court of Appeal, referred to what he describes as a helpful extract from Harvey W. Rubin's audit guidance series for the insurance company, the insurance terms, which he quoted, and which we can either look at it there or it appears on page 1575. But the important point is this: the renewal term life insurance, or yearly renewable term, was defined as meaning coverage that is renewable at the option of the insured, who is not required to take a medical examination. So regardless of physical condition, the insured must be allowed to renew the policy year on year, and the premium cannot be increased to reflect any adverse physical condition that occurs from year to year. However, the premium each year can increase to reflect the life expectancy of the individual at a particular age. So the table would have rates that would apply as assessed in relation to a particular policyholder at the date of the application, his or her physical condition at that date, whether a smoker, whether male or female, at that date.
It appears that they should be done by reference to risk class. You would look for certain criteria to determine whether this individual, as you read, was within a risk class, and you'd apply the rate for that risk class.
Yes. And you can pick up, in a sense, the important risk classes from the policy illustration. They're recorded there.
Yes.
The policy illustration is at 473. We had a brief look at this.
Just, if I could just bring you back to the earlier question. Is there a table?
I'll have to take instructions. But in terms of what was in evidence, no. Right. My understanding at the moment, and I could take instructions, is that the insurer did not disclose a contract at all at first.
The insurer didn't?
The insurer didn't. The version of the policy that was in the hearing bundles at first instance was produced by Mr. McPhee, the appellant.
And did your client have a position as to whether there had been a table, but it hadn't been produced by anybody, or whether it didn't know whether there had been a table or not because it had taken over the policy, or what was its position?
Well, my lord, the position was, I don't think that question was addressed. It didn't arise because of the way the issues were framed at first instance. Yes. And let me just address that point.
Yes, if Mr. McPhee had been right, then in his construction, namely that it was a fixed premium for the rest of his time and a fixed GCOI per year, the table was irrelevant. But it might have been a useful thing for the insurance company to have produced in explaining its policy.
It also might have borne on whether he was right, because it might make a difference whether there actually was a table or whether it wasn't, to what the policy meant.
It may have been useful. It may have been helpful on the issue, but the particular issue, as my lord has noted, is whether or not there was a contractual right to increase annually, or whether it was fixed. And that issue was the issue that the evidence was directed to, and it was both in terms of disclosure and in terms of witness evidence, and it was the issue to which the first instance judge directed her judgment. And I don't need to address that issue now. What I'm addressing now is a slightly different point. But what is said against me is just because the policy allowed annual increases, it doesn't follow that the insurer, the respondent, was entitled to apply the increases it had actually applied, as recorded in paragraph 10 of the amended defence. But the increases actually applied by the respondent were not in issue at first instance. It just were not. It was not said, for example, that the respondent should have increased the guaranteed cost of insurance to some other than $80 Bahamian and 25 cents on the second anniversary of the policy. Your table at paragraph 10 of the amended defence starts at page 18.
Well, did Mr. McPhee concede that if he was wrong in saying that the policy was to be interpreted as requiring no increases, the increases applied were contractually agreed increases?
He took no issue with the increases that were actually applied.
You just said they were all unlawful.
As a matter of principle, it was fixed, not increasing annually, so they were all...
That clearly was the issue being fought. Would that be a convenient place for us to take the short adjournment?
My lord.